9 justices, 0 dissents. One ruling that just redefined the exact moment a police officer can legally cross your threshold without a warrant. And the facts behind this case are so unsettling, so specific, and so deeply human that once you understand what actually happened inside that home, you will never think about your Fourth Amendment rights the same way again. Because this was not some dry legal technicality debated in a vacuum. A man was hiding in his own closet, inside his own home, and when he stepped out, he was shot by the very officers who entered without permission and without a warrant. The question the Supreme Court had to answer was whether those officers had any constitutional right to be standing in that hallway in the first place. And their answer just changed the legal landscape for every single law enforcement agency, every single courtroom, and every single homeowner in America. So, let me walk you through everything. How this case started, what constitutional crisis it exposed, what the court actually decided, and why the ripple effects of this ruling are going to be felt in patrol cars and courtrooms and on front porches across this country for decades to come. All the chain of events began with a phone call. Police received a report that a man named Trevor Casseis had made threatening statements to his ex-girlfriend. According to the report, he had suggested he might hurt himself and had warned that he would harm any officers who showed up at his door. That kind of call puts law enforcement in an incredibly difficult position, and anyone being honest about policing acknowledges that. Officers responding to potential self-harm situations face genuine danger and genuine moral weight. But what happened next is where the constitutional questions begin to pile up fast. When officers arrived at the home, they noticed an empty gun holster, which immediately raised concerns. They received no response from inside. They shone flashlights through windows. They called his name repeatedly. Nothing. Silence. No movement, no response, no indication of what was happening behind those walls. And then they waited. Not for 5 minutes, not for 10. They waited for more than 40 minutes outside that home without receiving any response from inside. And here is the detail that turns this from a routine police call into a landmark constitutional case. During that 40-minute window, some of the officers on scene openly stated that they did not believe anything was actually wrong inside the residence. They had doubts, real, documented, professional doubts about whether any emergency existed at all. Despite those doubts, officers eventually entered through an unlocked front door. Inside, they discovered Casseis hiding in a closet. When he emerged, one of the officers shot him. A handgun was later found in a bedroom. Casseis was subsequently charged with multiple criminal violations, but he fought back, and the weapon he used was the Constitution itself. He challenged the entire warrantless entry as a violation of his Fourth Amendment rights, arguing that officers had no legal justification to be inside his home without a warrant in the first place, and that every piece of evidence discovered after that entry should be thrown out. The case worked its way through the Montana court system, where the Montana Supreme Court upheld the entry using what is known as a reasonable suspicion framework, essentially a lower legal bar that gave officers more flexibility to justify crossing that threshold. Casseis then took his fight to the highest court in the land, and the United States Supreme Court agreed to hear it because this case was not just about one man in Montana. It was about a question that had been quietly tearing at the fabric of constitutional consistency across every state in the country. Here is what most people did not realize before this ruling and what makes this case so much bigger than any single set of facts. Courts across America had been applying completely different legal standards to the exact same constitutional question. When can police enter your home without a warrant during a perceived emergency? In some jurisdictions, officers needed probable cause, the highest and most protective standard. In others, they only needed reasonable suspicion, a dramatically lower bar that essentially requires officers to have little more than an articulable hunch. And in still other courts, judges were referencing something called an objectively reasonable belief standard from a prior Supreme Court case called Brigham City versus Stewart, but without clear guidance on whether that standard was actually the definitive national rule. The practical result of this confusion was staggering. A warrantless entry that would be deemed perfectly constitutional in one state could be ruled a clear Fourth Amendment violation just across the border in another. Your fundamental rights inside your own home were effectively determined by your zip code. That is not a legal technicality. That is a constitutional crisis that had been hiding in plain sight for years, producing inconsistent outcomes, unjust results, and a patchwork of protections that made a mockery of the idea that the Bill of Rights applies equally to every American. The Supreme Court had to choose between three competing frameworks, and the stakes of that choice could not have been higher. Set the bar too low, and the Fourth Amendment protection of the home becomes functionally meaningless, a paper guarantee that evaporates the moment an officer decides to characterize a situation as an emergency. Set the bar too high, and you risk a different kind of tragedy, one where officers who could have saved someone's life are legally paralyzed at the front door while a person bleeds out inside. What the court was really being asked to define was the precise constitutional boundary between the government's power to act and a citizen's right to be left alone inside their most private and protected space. And that boundary is one of the most consequential lines in all of American law. What all 9 justices agreed on the Supreme Court issued a unanimous 9-0 decision. Every single justice, across every ideological line, across every appointment by every president, arrived at the same conclusion. Police may enter a home without a warrant under the emergency aid exception only if they have an objectively reasonable basis to believe that someone inside is seriously injured or faces an imminent threat of serious injury. Not a hunch, not a general concern, not a vague feeling that something might be off. An objectively reasonable belief grounded in specific articulable facts that would lead a reasonable person to conclude that someone inside is in genuine and immediate danger. The court explicitly rejected Montana's use of the reasonable suspicion standard as constitutionally insufficient. It clarified that the emergency aid exception is its own distinct legal doctrine, separate from the standards that govern criminal investigations. And it made a point that will matter enormously in future cases. The mere presence of a firearm does not automatically justify a warrantless entry. Every situation must be evaluated on its own specific facts, and the existence of a weapon in the abstract is not a blank check for crossing someone's threshold. Perhaps most significantly, the court affirmed Montana's ultimate outcome, meaning it agreed that under the correct standard, the entry in this particular case could be justified, but it rejected the legal reasoning Montana had used to get there. That distinction matters enormously. The Supreme Court was sending a clear message to every lower court in the country. Arriving at the right result through the wrong constitutional framework is not acceptable. The reasoning matters just as much as the conclusion, because the reasoning is what protects every future defendant, every future homeowner, and every future officer who stands at someone's door facing an impossible decision. The fact that this was 9-0 carries a weight of institutional authority that is almost impossible to overstate. When justices who disagree on virtually everything find themselves in complete alignment on a constitutional question, it signals that the answer was not a close call. It was the only constitutionally honest answer available. That unanimity insulates this ruling from political criticism, makes it extraordinarily durable as precedent, and sends an unmistakable directive to every court, every agency, and every officer in America. This standard is not open to reinterpretation. It is not subject to local variation. It is the law of the land. The practical implications of this ruling are immediate and far-reaching. Every law enforcement agency in the country that had been operating under the looser reasonable suspicion framework must now update its training programs, field protocols, operational guidelines, and supervisory review processes. This is not a gradual transition or a suggested best practice. It is a constitutional obligation that takes effect now. Every training manual that referenced reasonable suspicion as the governing standard for emergency home entries must be revised, retested, and brought into alignment with what the Supreme Court has unanimously mandated. For criminal prosecutions, this ruling fundamentally resharpens the legal battleground. Defense attorneys now have a clearer and more powerful framework for challenging warrantless entries and arguing for the suppression of evidence. Prosecutors, in turn, must demonstrate with much greater precision that the specific facts known to officers at the exact moment of entry actually met the objectively reasonable belief threshold. The quality and completeness of an officer's documentation at the time of entry is no longer just good practice. It is the difference between evidence being admitted in court and an entire prosecution collapsing. The Casseis case itself provides a perfect illustration of how fine these distinctions can be. Officers waited more than 40 minutes. Some expressed doubts about whether any emergency existed. The gap between arriving on scene and crossing the threshold was filled with hesitation and conflicting assessments. Future cases will turn on precisely these kinds of details. What was documented? What was observed? What did officers actually know, as opposed to what they assumed or feared at the specific moment they decided to enter? Those questions will now be litigated with an intensity and specificity that the previous patchwork of standards never demanded. This ruling also builds on an earlier unanimous decision in Caniglia versus Strom, forming what constitutional scholars are describing as a reinforced wall around the American home. Taken together, these two 9-0 rulings send a powerful and consistent message. The emergency aid exception exists for genuine emergencies involving imminent danger to human life. It does not exist as a general public safety justification that officers can invoke whenever they feel something might be wrong. The court has drawn that line with unmistakable clarity, and it has done so with the full unanimous weight of the nation's highest judicial authority. As clear as this ruling is, it leaves open questions that will generate significant litigation in the years ahead. One of the most pressing involves mixed beliefs among officers at the same scene. In the Casseis case, some officers believed entry was necessary, while others openly doubted that any emergency existed. How should courts evaluate the legality of an entry when the officers involved cannot even agree among themselves about whether the constitutional threshold has been met? Can the documented doubts of some officers on scene be used to undermine the legal justification that others relied upon? Those questions are not hypothetical. They arise constantly in real-world policing, where multiple officers respond to the same call and reach different conclusions about what the facts require. Every new set of circumstances will test the boundaries of what objectively reasonable belief actually demands in practice. The doctrine will continue to develop as courts encounter factual scenarios that this ruling did not specifically address, gradually building a body of case law that will define the real-world meaning of this constitutional standard for generations. The unanimous foundation the Supreme Court has laid is extraordinarily strong, but the structure built on top of it will be shaped by the messy, unpredictable, intensely human situations that real emergencies produce every single day. What this ruling ultimately represents is something that transcends any single case or any single legal standard. It is a reaffirmation of one of the most fundamental principles in American constitutional law. Your home is your most protected space. The government cannot enter it lightly, cannot enter it on a hunch, and cannot enter it without meeting a standard that is serious, objective, and grounded in specific facts that would convince a reasonable person that someone inside faces genuine and imminent danger. That principle has now been stated unanimously by every justice on the Supreme Court, and it applies equally to every American regardless of which state they live in, which city they call home, or which officer shows up at their door. That's it for today, folks. See you in the next video.